Okay, our next topic on the Kentucky REALTORS Statewide Contract video vignette series deals with the appraisal contingency. Now, that contingency is contained within paragraph 5 of the statewide contract and appears on numeric line 80. Again, those numbers run along the side of the contract. Now, the important thing to note first is that you are given three options as a buyer making an offer, but you should only select one of the three options. Now, the first option is for transactions involving a lender, and that is option A, and that appears on numeric line 81. Now, the next one is option B, and that is for cash transactions, private finance transactions, and contracts for deed. That appears on line 83. And then finally, there is the option C, which says that this contract is not contingent upon an appraisal, and that appears on line 86. Now, an appraisal contingency is not an uncommon thing to find within a sales contract, but there are some parts of the statewide contracts version of that contingency or contingencies that I want to make sure that you look at and pay attention to, because they could affect your client down the road, whether your client's the buyer or whether your client is the seller. So let's start with option A on line 81. And it states that this contract is contingent upon the lender's first appraiser establishing that the value of the property is equal to or greater than the purchase price. So essentially, the buyer can get out of this contract if that first appraiser does not establish the value of the property as equal to or greater than the purchase price. Now, this is important, because it's the lender's first appraiser. So if the lender hires somebody and that person comes back and says, this property, you want to buy it, let's say for $500,000, and this appraiser comes back and says, this property is worth $501,000, the contingency goes away, right? Because the lender's first appraiser has established that value. Now, why is that important? Well, what happens if the buyer wants to get out of the contract and says, oh, well, no, that first appraiser missed some things, and I'm going to go hire another appraiser, and that one says it's only worth $480, so therefore I want to use the appraisal contingency to get out of the contract? It doesn't work. That contingency only applies to the lender's first appraiser. Now let's go to another situation. The first appraiser comes through and says that amount, seller knows about it, and then subsequently, the lender comes back and says, oh, well, we looked at this a second time with a different appraiser, and now it's not at the amount we need it to be. The question becomes, can the buyer utilize the appraisal contingency to get out of the contract? And I think pretty clearly, as far as using the appraisal contingency portion of the contract, they cannot. Now, this may raise a question as to whether or not they can use this subsequent appraisal to get out of the contract based upon the lender's financing appraisal contingency or financing contingency. That's an open question. There could be an argument that yes, they should be able to do that because they didn't get the loan. But there could also be an argument that no, they should not be able to do that because the appraisal part of that loan process has been addressed in another section, and if they satisfied it there, that they don't ultimately get the loan is not, and it's based on that reason, that should not apply. So it gets a little tough in there, and I don't think there's been a clear delineation as to what would occur in that situation. But now let's go on to option B, which is on line 83. This is for cash transactions, private finance transactions, and contracts for deeds. It states that this contract is contingent upon an appraiser from a Kentucky certified real estate appraiser chosen by the buyer. Now, this is important because in the first section, it was an appraiser that was chosen by the lender. In the second section, it's an appraiser chosen by the buyer. And the key component of this is the next part, because it said it is contingent upon an appraisal which would be completed within blank number of days. The thing you need to focus on is the completed word in there, because you who are assisting the buyer in preparing this contract, meaning the selling agent, you need to remind them that this doesn't mean that they order the appraisal within a certain number of days. That means that it needs to be completed. So let's imagine the situation that the buyer puts down 10 days. And on day 9, they decide, oh, well, you know what? Everything else passed on inspections. Let's go ahead and order that appraisal. And they go and they order that appraisal, and it comes back 15 days later. Can they use this contingency to get out? No, because it wasn't completed within the time frame that the buyer had agreed to. On the flip side, as a listing agent, you need to look at that number where it says completed within blank days. You need to look at that number and talk to your client, because if that's a really long number, that is that much longer that your client's property is locked up with a contingency that your client can't control. And it's contingent upon an appraisal that your buyer hired, or that the buyer hired. So again, in this situation, the buyer wants to have as long a period of time as they can there, and the seller wants to have as short a period of time as they can there. At the same time, the buyer wants to have a time period that's short enough that doesn't scare away the seller. So that number could be important in the long run, especially in a fast-moving market. Now, let's look at paragraph C, or option C, which is on line 86. Now, this is very simple. It says this contract is not contingent upon an appraisal. So if you check that, you are obviously making your offer more attractive to the seller, but there is a little bit of confusion that may come about, or a dispute that may come about when you check that. Because if you check that, again, this may establish an argument that if the appraisal is the reason your lender declines your loan, there may be an argument that you can't use the financing contingency to get out of the contract, because it's already been addressed in this paragraph, and you've already told them this isn't contingent upon an appraisal. That is a tough question. I don't know the answer to it. I've seen it raised by competent, reasonable attorneys on both sides, and we've not had a case come back on it yet. So just be conscious of that if you are, in fact, in this type of transaction. Now, the next part on line 87, and just to be clear, line 87 is not connected to line 86. It is a new paragraph. But line 87 says, should the appraisal establish that the value of the property is less than the purchase price, in order for the contingencies in A or B to be effective. Okay, so that means that, all right, you've checked A or B. Now it's saying that's fine, but in order for you to utilize that contingency, you must do the following. Now, what it says is that buyer must, within 5 days of discovering the appraised value, and in writing, either A, waive the appraisal contingency, B, agree with the seller on a new purchase price and or payment items, if necessary, or C, void the contract, at which point buyer shall receive the earnest money deposit and refund. Now, this is important. What this is really saying is that once the buyer knows that the appraisal has come back and it hasn't appraised to the contract price, they have 5 days. They have a lot of power, but they must utilize that power within 5 days. Now, the first question is, what does discover mean? Does that mean they actually get the appraisal? Does that mean they get a phone call from the bank? Does that mean they get a phone call from the appraiser? What does it mean? Well, I can tell you that this is purposely vague, because we recognize that there are a lot of different ways that you could discover that the appraised value, that it hasn't reached the appraised value. So it is incumbent upon the buyer to assume that the earliest date is the one that a court or an arbitrator might determine to be the date they discover the issue. So we also want to encourage communication between the buyer and the seller. So a buyer who sits on information is potentially going to lose the power they have within that 5 days. So let's assume, though, that the buyer says, oh, I just got a call from the appraiser. I need to let the seller know. They immediately put in writing, hey, seller, here's what I know, and I am going to select one of these 3 options. Okay, 1, they waive the appraisal contingency. That's simple. They say, I'm going to close, and it doesn't matter what the appraisal says. Section B, I'm going to work something out with the seller to try to come up with a new purchase price or payment terms. That's fine. That can happen, but it involves both notifying the seller of the issue and then getting the seller's agreement. And then finally, there's C, which is them to say, you know, I'm just going to utilize the contingency. I'm going to get out of this contract. I'm going to void it, and I'm going to get my earnest money deposit back, which again, in that 5-day period, they have that power. Now, the next sentence talks about what will happen if the buyer doesn't utilize any of those options within that 5-day period. If they don't, it says, otherwise, the contract is voidable at the option of the seller, and the seller shall retain the earnest money deposit. So, the seller at the 5-day passage time, once the 5 days has passed, has two things it can do. It can say, this contract is enforceable, and we're moving forward. Or it can say, I'm done with this contract, I'm done with this buyer, and I'm keeping the earnest money deposit. Because the buyer who had that power in that 5-day period has waived it. So keep that in mind. That 5 days is incredibly important. By making the buyer communicate this to the seller, we're encouraging transparency in the process. We're trying to make sure the seller hasn't locked up their property while the buyer's basically being dishonest and not disclosing what's supposed to be going or what's going on in the transaction. And we're giving the buyer a lot of power, but only for a short window of time, and then all the power shifts to the seller. So hopefully this discussion has helped you. Our next video vignette will be on due diligence, and it is one of the areas that is most ripe with dispute. So I hope you sit in for that. It may be a little longer than this one. And hopefully we've assisted you in utilizing the KYR statewide contract.